I don't know what Ingray Jones is. I don't know why you looked at that. You know, I don't like vague entries. If I've asked you to do a memo, send me a bill when you're concluded with the memo. I don't want to get a bill 1 month that has a bunch of research time and not have the memo yet. Now, if it's litigation or if it's a really complicated contract, I think that's just fine. I mean, we all expect that those bills will go on for a long, long time. But if it's a research topic, or if it's something that can be handled, you know, in the span of a month or two, I think it's better to just wait until you're concluded and send a bill at that time. My last one is billing entries that I get 6 months late or a year late. So it's kind of, I realize I'm talking out of both sides of my mouth a little bit, but I don't think any client enjoys being surprised. I don't think any client enjoys getting 6 months worth of entries and realizing, you know, what they thought was a simple bad check issue has now turned into a, you know, $25,000 legal bill. So just be timely with your bills. And then a simple thank you for your business makes us feel appreciated. I often joke I have to be a lawyer's worst nightmare as a client. You know, I know we're not always easy as clients. We have high expectations. I know my clients internally at the bank have high expectations of me. You know, the way I look at it is, my loan officers every day have the choice. They can pick up the phone and they can call me, or they can fire me and start using outside counsel again. I appreciate them. I tell them thank you for calling. And I think the same holds true for outside counsel as well. You know, thank you for calling. We like that. We're probably more likely to call you then if we have some tangential issue that, you know, maybe we wouldn't have called you about 2 years ago. But if we feel appreciated, we'll give you a call. I talked fast in the interest of time. Thank you, everyone. If anyone has any questions or comments, I'm happy to answer them, but in the interest of time, I'll move on.
Very good, all right. All right. Judge Nails, our next presenter, well known to many, but just a reminder, has extensive experience both as a private practitioner, Chapter 7 trustee, in a sophisticated administrative position in the clerk's office. Now bankruptcy judge, and was appointed, I saw, to the 8th Circuit back in 2010, I believe. So let's welcome Judge Nail.
Thank you, Tom. Like Christina, I was worried I was not going to be able to see over the stand here. I'm always nervous when someone introduces me and they go through my background, because the first conclusion I come to is that I was not able to hold a job, since I've held so many over the course of my career. I understand that the crowd this afternoon is not composed entirely of bankruptcy practitioners. I would have figured that out myself by looking around and seeing a few unfamiliar faces. We have a small bankruptcy bar, and I do think I recognize most of the practitioners, both because of my time on the bench, but also because of my 11 years as the clerk and my 7 years as the assistant U.S. trustee here. So those that have been around for the 25 years that I've been around are familiar to me, and I think I'm familiar to them. I don't think I surprise too many people with any of my rulings, because they've dealt with me for those 25 years, and I like to think that I'm consistent in the way I approach things. So I don't think I have too many surprises for anyone who's been around for all that time. What I would like to do this afternoon, though, is talk about a few cases that have implications beyond bankruptcy, things that attorneys that don't practice bankruptcy should probably be aware of in their day-to-day practice. And I'm also going to try to make those cases somewhat of a reminder for those of you that do appear in front of me on a regular or semi-regular basis. I'm going to follow along the materials fairly closely, so you may want to do the same. Of course, having said that, I'm going to first talk about a case that is not in the materials. The first area we're going to talk about has to do with divorce and the relationship between divorce and bankruptcy, which seems to be a fairly close relationship in any number of cases. My first rule of thumb, and probably the most important piece of advice I'm going to give you about divorce and bankruptcy, is do one or the other, and then the other, not both at the same time. There are circumstances that suggest you do the divorce first and then you file for bankruptcy, because there are implications in bankruptcy if you have a two-income family. even though they're separated, that may cause them problems in staying in Chapter 7. So you may want to think about getting the divorce done first and filing separate cases. There are circumstances in which you want to file the file the bankruptcy first. Obviously, if you file the bankruptcy first, then the only thing you're dividing up in the divorce is the assets. You're not going to be fighting over the debts, because those debts will be gone. Things happen and they're not good necessarily when the divorce and the bankruptcy are happening at the same time. And that leads to that case I was talking about that's not in the materials. It's the Stephen Wolk case, bankruptcy number 0950082. It's a bench ruling from September 17, 2009. All you really need to know is the last name, because if you look on the web page, you'll find the case there, and you'll also find the actual bench ruling itself, an audio recording of the bench ruling. The specific issue in that case was whether the debtor's estranged but not divorced spouse was entitled to relief from the automatic stay in order to pursue a property settlement in the divorce court. I'm going to assume that I don't need to explain too much about the automatic stay, but briefly, the filing of a bankruptcy creates an automatic stay that precludes creditors from taking action against the debtor. The stay can be lifted for cause, and the cause in this case was alleged to be the need for the divorce court to divvy up the property. The problem is, and the problem was in that case, that the filing of the bankruptcy case also creates a bankruptcy estate. And all the property in the bankruptcy estate is subject to my exclusive jurisdiction. And I don't say that with any sense of pride, it's just the way the statute is written. The divorce court does not have jurisdiction over anything that comprises property of the estate. Now that's a practical issue for the attorney, because I'm not sure you really want to go into the divorce court and say, you don't have jurisdiction over this, judge. If you want to do that, that's fine. But if you could avoid it by not filing the two or pursuing the two matters simultaneously. In any event, I denied the relief from the stay because of my exclusive jurisdiction over the property of the estate. That did not make the estranged spouse necessarily happy. I did point out, and it's something to also bear in mind, that while I have exclusive jurisdiction over property of the estate, there are still things that the divorce judge can do. And I talked about these in the case. The divorce court could take jurisdiction over any exempt property, because that's no longer property of the estate. The divorce court would have jurisdiction over any post-petition earnings, in a Chapter 7 at least. Those post-petition earnings are not property of the estate. Could take jurisdiction over any property that's excluded from the bankruptcy estate. The property of the estate is fairly all-inclusive, but there are exceptions, and those are provided in Section 541. So the state court would have jurisdiction over that. The state court would also have jurisdiction over property abandoned by the Chapter 7 trustee. The only problem with that is the reason the trustee abandons property is because it's worthless to the estate. If it's worthless to the estate, I'm going to go out on a limb and suspect it's also worthless to the sparring spouses. You can also, the state court would also have jurisdiction over any surplus under Section 726A6. That's the provision that says that once all the property has been distributed, all the creditors have been paid in full, any surplus remaining goes back to debtor. So the state court would also have jurisdiction over that. I don't think we have very many surplus cases, do we, Trustee Pierce?
Not a lot.
We have some, but we don't have a lot. So while I would have exclusive jurisdiction over the property of the state, I did say that the state court could proceed to consider any of those kinds of items in determining an equitable property distribution. The other thing I said was, and this was a little subtle, is that while the state court couldn't divvy up the property of the estate, it could take the property of the estate into account in determining an equitable distribution of the property. In other words, all of the state property could be assigned to the debtor, and anything else that wasn't estate property could be assigned to the spouse in order to balance things out. So there's nothing wrong with that, even though if it were outside bankruptcy, the estranged spouse might have gotten some of the property of the estate. Give the debtor credit for all of that, give the estranged spouse the credit for anything left over. So that's an example of why we don't want to be doing this simultaneously. I suspect that trying to go back into the state court and explain what I just said was a little bit frustrating. for all the parties concerned. Something else that you're going to want to be aware of in terms of the timing of cases and which goes first. Alimony, an award of alimony, if it's entered pre-petition, is property of the estate. It doesn't belong to the debtor. So if you've just successfully concluded a divorce and you've gotten your client $500 a month in alimony, and then you file the bankruptcy, the trustee is going to then file a motion for turnover and ask that those future payments of alimony, for as long as the case is open, be turned over to him or her. And it's going to be ordered to be turned over. So you're going to want to make sure that you at least make your client aware of that, because that's, again, not a conversation you want to have with your client after you've told them, we're going to get this divorce done and we're going to file bankruptcy, and oh, by the way, that $500 a month of alimony that you were counting on, you don't get to keep it. So you want to be aware of that. That's the Melhoff case. That's the first case in the materials. I will note, just for the sake of accuracy, that when I'm citing to the affirming opinion, debtor did not change her name. Her name still remained Melhoff. The Hellhoff is a typographical error that somehow eluded me, my law clerk, and my clerk, who we call Eagle Eye for his proofreading skills. While alimony is property of the estate, child support is not property of the estate. The way the statute reads, the parent holds the child support in trust for the children, and since it's held in trust for the children and the debtor is acting as a trustee for the children, it is not property of the estate. Trust property is one of those exclusions that I mentioned earlier under 541. So alimony in, child support not. Pay attention to the language of the settlement agreement that you're drafting in the divorce. In the Bone case, which is also on page 1 of the materials, the agreement provided that the debtor could have the home, or the deal was the debtor tried to claim exempt any proceeds in a future sale of the property under the settlement agreement. The problem was that the sale had not taken place when the bankruptcy was filed. Therefore, there were no proceeds for the debtor to claim exempt. And I overruled the objection and disallowed it so that the debtor wasn't able to claim this $10,000 in the home. I did say, however, that because that was the right to those payments was a personal property interest, the debtor was able to use the wild card exemption. Let me get this wrong now, $4,000 for an individual, $6,000 for a head of family, $10,000 for a joint couple. That's now $5,000 for an individual, $7,000 for a head of family, $12,000 for a jointly filing couple. Could use that exemption to claim a portion of the proceeds when the house was ultimately sold. As you're all aware, in order to claim a homestead, you have to occupy it as your homestead. You can be away from it temporarily, but you can't abandon it with the intent not to return. In the Herding case, there's also on the first page of the materials, we had a Chapter 7 debtor claiming a homestead exemption in the marital home that he vacated prior to filing pursuant to a protection order. Even though his leaving the home was not voluntarily, he did leave it without the intent to return. Therefore, I believe that this was mine, I think, not Judge Hoyt's, this was mine, also said that could not claim a homestead exemption in the property once he abandoned it pursuant to the protection order. A similar situation in the Fugue case. The debtor did not live in the marital home on the petition date. She vacated it when she separated from her husband. There was some reference to the possibility that she might return to it someday if her husband decided to move out or if her adult son needed care. That was prospective. It wasn't the case on the petition date, and therefore I overruled the objection and did not allow her to claim the exemption. And I say I did it. Actually, that one was Judge Hoyt's because it was April 2006 before I took the bench. So the takeaway regarding divorce and bankruptcy is, and I'll repeat it again because we've said this over the years in a variety of settings, and we still see it happening. So we're not getting through one or the other, and then the other. Don't do both at the same time. Be aware of what's going to come into the bankruptcy estate. If you file the bankruptcy, alimony in, child support out, and make sure that any settlement agreement that's signed before the bankruptcy is filed says what you want it to say. being aware that when you file the bankruptcy, the property, the estate, and the exemptions are going to be determined by federal law. Okay? Any questions about divorce? Well, let me rephrase that. I couldn't answer a question about divorce. I know nothing about divorce. Any questions about divorce and bankruptcy? Then I might have a little more expertise on it. Yes?
So if the judge makes a decision that one spouse or the other has more liability, they can file bankruptcy and you get to decide whether or not that was a good allocation?
Well, I won't decide whether the allocation was correct, but if the judge assigns particular debts to a particular one or the other, and that one files, I will discharge those debts as to the creditors. Now, because it was in connection with a divorce, the spouse's obligation to the other spouse is non-dischargeable. So while they may not be required to pay MasterCard or Visa, if the non-filing spouse has to pay them in order to protect their credit, the obligation to pay the spouse back is going to be non-dischargeable. So they can't beat the divorce, the allocation of the debt, but they may not have to pay the creditor directly. Clear as mud?
No, I understand.
Okay. Anyone else? Okay, let's talk about cars. The only thing more important in Chapter 7 in South Dakota than cars are Harley Davidsons. We don't mess with motorcycles. People will sell their dog and starve their children in order to keep their Harleys. Nothing like a reaffirmation agreement on a Harley Davidson that I have to approve when I know that they can't make the payments. Cars are also important. If you believe the debtors, every debtor, there has to be one car per person in the household. I'm not, well, I am that old. When I grew up, my family had one car. We seemed to survive just fine, but no family today can survive on just one car. You've got to have 2, 3, or 4. So, here's what you need to know about cars. Look at the certificate of title. The name of the owner on the certificate of title, and this is a tricky one, the name of the owner on the certificate of title is the owner of the vehicle. Okay. Now, everyone in here that doesn't practice bankruptcy is going, what? Well, you'd be surprised at the stories I hear. The vehicle's in the debtor's name, but that's only for insurance purposes. The vehicle's in the debtor's name because our child couldn't qualify for credit. The vehicle's in the debtor's name for any other number of reasons. What I hear when a debtor's attorney says to me the vehicle is titled in our name for insurance purposes, what I actually hear in my head is we trick the insurance company by claiming we own the vehicle when we really don't. When I hear it was put in our name because our son didn't have good enough credit to buy it, I hear we tricked the lender by telling them that we owned it, not our son. Doesn't go over well with me. I'll say it again. The name on the certificate of title is the name of the owner of the vehicle. That's the Reindlinger case on page 2 of the materials. The argument was made that for both those reasons, both for insurance purposes and because the son did not have adequate credit, that they put it in the parents' names, but it was really their son's vehicle. And I said, no, it's really your vehicle, and the trustee's entitled to possession of it and to sell it. Now, what if the debtor's name and someone else's name is on the vehicle? Okay? Go back to my initial theory. The name on the certificate of title is the name of the owner. Well, we can make it plural. The names on the certificate of title are the names of the owners. So if debtor and another party are named as the owners of the vehicle on the certificate of title, the debtor is at least a partial owner of the vehicle. Don't want to hear about insurance. Don't want to hear about credit. The debtor is at least a partial owner of the vehicle. Now, how do we decide what the debtor owns in the vehicle? The presumption is going to be if there's 2 names in the title, they each own it equally, 50%. That's going to be the Taylor case cited on page 2. Now, that presumption can be overcome by evidence of disparate payments. If, in fact, the debtor and her son are on the vehicle, the presumption is going to be that they both own 50%. If the evidence is put forward to me that the son made the down payment and made all the payments, I'm going to find that that presumption's been overcome and that the son is in fact the owner of the vehicle. If the son made a third of the payments, the son's going to be a 1/3 owner. Okay, but the presumption is divided equally. That can be overcome by not the debtor coming in and saying, my son made all the payments. The debtor coming in and showing me checks or payment receipts or a payment coupon book or something. Some evidence that demonstrates that in fact the son made more than 50% of the payments.
Is there any distinction made if the title says and or and, as long as they're both on there, considered both co-owners?
I don't think I've had that issue presented, Tom. My initial reaction, although I don't give advisory opinions, my initial reaction is it's not going to make a difference. One other thing on vehicles, if there are no other questions about ownership, security agreements against the vehicle. I have held in 2 cases, that being the Bucky case on page 2 and the Irvine case on the top of page 3, that merely noting a lien on a certificate of title isn't enough, that there needs to be a separate security agreement granting that security interest. The notation on the certificate of title, in my mind, is perfection. You can't have perfection unless there is a granting of a security agreement. And in those 2 cases, and you can read the cases to figure out why I said this, but you need to have a separate security agreement granting the security interest. In both those cases, the liens that were noted on the title were family members. I'm not a cynical person, but sometimes I am. And when I see a family member getting a lien noted on a certificate of title with no separate documentation, I wonder whether or not the lien was honestly and legitimately granted. Particularly when in one case I think the lien was noted on the certificate of title the day before the petition. I think that was the case. So, separate security agreement, got to produce that, got to produce the certificate of title showing the lien was noted on there. There are some other cases regarding vehicles that are cited on page 3 as well. This has more to do with the timing of perfection. That's kind of an issue that's had its day and gone. It seems to be most of our bank lenders got word of these cases sometime after they were entered. Basically, the problem was the bank was lending the money for the vehicle. They were putting their name on the certificate of title and giving it to the debtor to take down and register. The debtor might shove it in the glove compartment, or the debtor might forget, whatever else happened. But they weren't getting it done before the case filed, or they weren't getting it done within the preference period, or they were getting it done within the preference period, 90 days pre-petition. That creates a problem for the lender, and so, and these are all Judge White cases, these cases are that long ago, the lien goes away, and the vehicle is suddenly free and clear of the lien, and that makes the trustee very happy, because they now have a vehicle that they can sell and distribute to the creditors. We haven't seen that much in recent years because, as I say, word spread and lenders stopped doing that. They started making sure that the certificates of title were registered much more quickly, and so the issue hasn't come up. In the original draft of the materials, we actually had the makes and models of the cars. Trustee Lovell had quite a run. For a while, they had a cottage industry in this, and was making doing a fair business in lien avoidance. In the last one, I think it was, noted on page 3, the attorney for the lender is now the clerk of the bankruptcy court, and we were having some fun with that. We were having more fun than he was having. Anything on security interest in vehicles? Okay. Let's move on then to non-dischargeability. I want to talk about 2 areas in regard to non-dischargeability, section 523A4. And don't worry if you're not familiar with the numbers, we'll talk about what the numbers are. And 523A6. We're not going to talk about 523A2. That's your basic fraud. And it seems to me that most attorneys, whether they practice a fair amount of bankruptcy or don't, they kind of get the fraud part of it. The only trick with 523A2 is you have to be careful in distinguishing between fraud that has to do with the debtor's financial condition or other fraud, because if it's fraud that has to do with the debtor's financial condition, you can't bring it under into A, because that's an oral representation. An oral representation having to do with the debtor's financial condition is not actionable. If it's going to be regarding the debtor's financial condition, it has to be in writing, and that's 523A2B. So you got to be careful about the statements regarding debtor's financial condition. Don't act on oral, you have to have it writing. And that's really the only area that we have any issues in regarding 523A2. 523A2. 523A4 has 4 different kinds of things that are accepted from discharge. And again, I don't want to offend anyone. The whole goal of a bankruptcy is to get a discharge, wiping out of the debts. 523 contains a number of exceptions to discharge, debts that will not be discharged if certain things are proven. So the debtor would get a discharge and all the other debts would go away, but this particular debt would not go away. It would survive the bankruptcy. So the first kind of actionable thing under 523A4 is fraud by a fiduciary. I set forth the elements in the materials. I'm not going to read those to you. You can read them yourself. I want to talk about a couple of the elements, however.